Shukrani Mwenyezi Mungu. Yote yawezekana bila Kawira, yote yawezekana bila Kawira.
Barabara mpenzi mtazamaji wa habari zetu, natumai mali popote ulipo upo mzima na buheri wa afya. Karibu nikupashe. Hivi sasa mambo yanayozidi kutrend katika mitandao ya kijamii ni kuhusiana na kubanduliwa mamlakani ama impeachment yake Kawira Mwangaza. Bado ndiye aliyekuwa gavana wa Meru County hadi kubanduliwa kwake hapo mwaka jana. Hii leo katika mahakama ya the appeal walikuwa na appeal kesi ya kubanduliwa mamlakani kwake Kawira Mwangaza. Ikikumbukwa Kawira Mwangaza alikuwa kati ya watu kipaumbele, marafiki au masidi wa ndani wake William Samoei Ruto ambao walipata kufurahia siku ambayo Rigathi Gachagua alipata kubanduliwa mamlakani, na hivi sasa yamepata kumkuta, ambapo ikikumbukwa sasa Kawira Mwangaza atakuwa anaweza kusimama kiti chochote cha kisiasa au kuajiriwa mahali popote katika ofisi za kiserikali. Hili ni jambo ambalo wakaaji wa pale Meru County wamepata kulipokelea kwa furaha sana, huku wakionekana wakipiga sherehe bwembwe, na huku wengine wakiahidi kupika chapati hii leo. Tazama video hii, pia usisahau kusubscribe, like, share and comment. Na hivi sasa tuko na habari njema, ambapo ni kana kwamba kama habari zetu zinapata kukufurahisha, unaweza kutumia zawadi katika the gift button ambayo ipo kwenye YouTube channel yako. Pia unaweza kutuandikia messages za kile unataka tushughulikie katika video zetu hapo next. Usisahau pia kusubscribe, like, share. Tunatufuata katika mitandao ya kijamii kama Visign Media across all social media platforms.
The purpose of sub judice is to ensure that judicial decisions are made without interference or parallel proceedings that could lead to conflicting judgments. The sub judice principle is well established in Kenyan law and is expressly recognized under Standing Order 92 of the Senate Standing Orders. Standing Order 92 states that senators shall not refer to matters that are pending in court if doing so would prejudice the fair determination of the case. However, the Standing Order also includes an exemption, allowing the Senate to proceed if the Speaker determines that the matter is of overriding public interest. This means while the doctrine of sub judice generally applies in the Senate, it is not absolute, particularly in cases where the Senate is exercising its constitutional oversight functions. Courts have also provided guidance on the application of sub judice. In Kenya National Commission on Human Rights versus Attorney General 2020, the court stated that the sub judice rule is meant to protect judicial proceedings from undue influence and ensure that courts, rather than legislative bodies, are the final arbiters of legal disputes. However, in Republic versus Chief Magistrate Milimani and two others, ex parte Tusker Mattresses Limited and three others, 2013, the court clarified that sub judice only applies when the matters being adjudicated are substantially similar and the second forum's decision could prejudice the ongoing court case. Therefore, the critical question is whether the Senate's deliberations were substantially the same as the issues pending in the High Court in Meru and other courts, and whether the impeachment proceedings prejudiced or would likely prejudice the fair adjudication of the pending cases. Despite the petitioner's reliance on the sub judice rule, the Senate was not necessarily barred from proceeding with impeachment. The respondent argues that the Senate Speaker was within his powers to allow the process to continue under the public interest exception in Standing Order 92. Furthermore, courts have consistently ruled that parliamentary proceedings, including impeachment, should not be halted simply because there is a pending court case unless there is a direct risk of judicial interference. Neither the petitioner nor any of the interested parties supporting the amended petition have been able to demonstrate a sufficient likelihood that there would be, or there would likely be, a significant negative effect from the Senate having considered matters that were the subject of pending court cases. A Senate resolution that touches in whole or in part on a subject matter that is pending in courts of law is, of course, not binding on those courts. They are free to independently arrive at the same or an opposite finding. To successfully invoke sub judice, a petitioner must show more than the concurrent consideration of the same subject matter. Rather, the petitioner must show a real, current, or likely, or future threat to his or her rights and/or the rule of law and the proper administration of justice by that concurrent consideration of the same subject matter. To hold otherwise, as a general rule, would be to subordinate the Senate's exercise of its constitutional mandate with regard to impeachment to judicial processes whose progression and timelines may be uncertain. The doctrine of separation of powers must be a two-way street. Unless in clear cases where there is an identifiable threat to constitutional rights, the rule of law, and/or the proper administration of justice coupled with a significant harm or the likelihood of significant harm, Parliament's discussion of a matter pending before a court of law should not result in the invalidation of any consequent action it takes. Parliament should, of course, exercise great restraint in deliberating matters that are pending before the courts, and should do so in a limited manner, and should do so very rarely and only in the most pressing of instances. Parliament is not just any other body. It is a collection of elected and nominated representatives of the people of Kenya, sitting in two houses that are deliberative chambers with immense gravitas and the ability to shape and sway public opinion. I note that the petitioner has articulated a similar sub judice challenge in the Meru High Court matter, directed at the proceedings before and by the County Assembly. This court's findings on sub judice are limited to the four corners of this amended petition and the impugned proceedings and resolution of the Senate, and this court makes no finding on that sub judice element as it applied to the County Assembly's proceedings. In conclusion, under this limb, it is the finding of this court that the amended petition has not successfully laid the required basis for interference by this court with the resolution of the Senate on the grounds of sub judice. Next, whether Section 33, subsection 8 of the Constitution of the County Governments Act contravenes Article 50, Clause 2, Paragraph O of the Constitution and is therefore unconstitutional. At this juncture, it is proper that this court comments on the petitioner's choice of filing and arguing two distinct High Court constitutional petitions concurrently, one in Meru against the County Assembly's actions and another in Milimani, Nairobi against the Senate's impeachment process. The respondent and the interested parties who oppose the amended petition have unsuccessfully argued that the present proceedings are sub judice those pending before the Meru High Court, and they are unsuccessful in that regard because even from their own filings it is clear that they appreciated the distinction between the two cases. With regard to Section 33, subsection 8 of the County Governments Act and its alleged unconstitutionality, the petitioner has conceded that an identical prayer has been advanced in the petition pending before the High Court sitting at Meru. Given that the Meru matter was filed first in time, it is fit and proper that it be the one to determine this issue, notwithstanding that the parties herein all extensively submitted on this limb of the amended petition. By filing two distinct petitions in two different stations, the petitioner has created an uncomfortable situation where, in essence, there is a possibility of the petitioner enjoying two bites at the cherry, as it were. Perhaps more importantly, the petitioner's choice of crafting two distinct petitions with minimal overlap, such that consolidation would not be automatic, has had the consequence of denying a single court a bird's-eye view of the entirety of the process, from the inception at the County Assembly to the Senate resolution, and thus forcing two High Court stations to tread carefully so as not to stray into the other's case. To be clear, this was not forum shopping, but rather it was clever lawyering, where the petitioner's counsel identified a loophole that they could use to the benefit of their client. By drafting and filing a petition before this court in which all the allegations were limited to the Senate stage, and by only suing the Senate Speaker, perhaps fully aware that the County Assembly and its officers would be forced to join the proceedings through applications for joinder, the petitioner has created a situation where she now has two opportunities for success rather than just one. As discussed earlier under the limb of the court order and whether it was violated, this court is limited by the amended petition to only the Senate stage aspect of that limb, with the petitioner still having another opportunity in the County Assembly stage challenge of the same limb, which is pending before the High Court in Meru. As we continue to fine-tune the practice and process of litigation in the High Court on the subject matter of gubernatorial impeachments, this is certainly a loophole that must be firmly closed by the courts in future impeachments, if a similar situation were to arise. This would not only make adjudication of the dispute more wholesome and comprehensive, but it would also ensure that all the petitioner's grievances are laid before a single court, which would be able to take a holistic view of the matter rather than being constrained to a more limited view. Therefore, while the constitutional validity of Section 33, subsection 8 of the County Government Act poses legitimate legal questions, both in favor of and in opposition of its constitutionality, this court declines to determine the same within this judgment, as the same is pending before the Meru High Court in a related matter which was filed earlier in time. Whether the threshold for public participation was met in the impeachment process. The issue of whether the threshold for public participation was met in the impeachment process is central to the petitioner's argument that the impeachment proceedings were unlawful. Public participation is a constitutional requirement under Article 10, Clause 2, Paragraph A, and Article 196(1)(b) of the Constitution of Kenya 2010, which mandate inclusive and meaningful citizen engagement in government decision-making, including legislative processes such as impeachment. However, public participation in impeachment proceedings primarily occurs at the County Assembly level rather than at the Senate level, since the County Assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for the final determination. The petitioner contends that the public participation process was inadequate or manipulated, thereby rendering the entire impeachment invalid. However, the respondent and the interested parties who support the respondent maintain that public participation was conducted in compliance with legal requirements, and any challenge to its inadequacy should be directed at the County Assembly rather than the Senate. Once more, this court is treading delicately so as not to stray into the province of a petition that is pending before the High Court in another station, and thus refrains from an in-depth analysis and determination of this issue, despite the parties having canvassed it at great length. This situation, as stated earlier, is a direct consequence of the drafting and filing choices made by the petitioner, which resulted in two live but distinct petitions pending before the High Court sitting at Meru and sitting at Milimani, Nairobi. Given that the petitioner has not sought adverse orders against the County Assembly, The court finds it procedurally improper to determine this issue in the present petition, as it is already being addressed in a separate case before the Meru High Court, in which the matter of public participation is at the core of the petitioner's grievance against the County Assembly. For the purposes of this amended petition, it is the finding of this court that the amended petition has not shown a correlation between its allegations on public participation and justiciable grounds against the respondent and the Senate within the four corners of the amended petition that is before this court. The next issue, whether the threshold for impeachment of the petitioner was met. The question of whether the threshold for impeachment was met revolves around two key legal considerations: whether the charges against the petitioner constituted valid grounds for removal under the Constitution, and whether the High Court should conduct a merit review or a process review of the impeachment decision. The petitioner and the interested parties who are in support of the amended petition contend that the allegations against her did not amount to gross misconduct, abuse of office, or gross violation of the Constitution, as required under Article 181, Clause 1 of the Constitution. On the other hand, the respondent and the interested parties who oppose the amended petition argue that the charges presented before the Senate were serious and substantiated, thus meeting the legal standard for impeachment. The Constitution of Kenya 2010 under Article 181 Clause 1 states that a governor may be removed from office for 1. Gross violation of the Constitution or any other law; 2. There being serious reasons to believe the governor has committed a crime under national or international law; 3. Abuse of office or gross misconduct; or 4. Physical or mental incapacity to perform the functions of the office. These requirements are mirrored in Section 33 of the County Governments Act, which outlines the procedure for impeachment, requiring an initial resolution by the County Assembly followed by a Senate hearing and vote. The Senate is tasked with evaluating the sufficiency of the charges and determining whether the evidence meets the constitutional threshold. Courts have consistently ruled that impeachment is not a purely political process, but one that requires objective and verifiable evidence of wrongdoing. Several landmark cases have clarified the legal threshold for impeachment, reinforcing the principle that impeachment must be based on substantive proof of serious wrongdoing. In Martin Nyaga Wambora vs. Speaker of the Senate and others 2014, the Court of Appeal held that impeachment must be based on evidence of gross violations of the law, not on minor procedural errors or political differences. The decision emphasized that governance mistakes or administrative inefficiencies do not automatically